Good afternoon, everyone. And I'm here to give you a little bit of a small background on how to write wills and the rules of succession, which is involved in wills. So, a lot of people normally come to us and ask about estate planning. And people have this impression that estate planning is creating a will. That's not necessarily accurate because estate planning is actually a comprehensive plan which has two components. The first component is that this plan would have documents which would be effective during the lifetime of the planner, as well as have documents which will become effective upon the death of the planner. Okay. And I'll make a distinction between the two different kinds of documents. What are some documents which are effective during the planner's lifetime? For example, deeds of sale over real estate properties, deeds of assignment over personal properties, deeds of a donation, or lifetime use of right over sold properties. All of these documents take effect during the planner's lifetime, and all of these documents are also part of an estate plan. And what are documents which become effective upon the planner's death? There are multiple documents, but some of the more common ones are a written will and an estate trust. What is a written will? A written will is a document which contains the dispositions of your estate. On the other hand, an estate trust is normally a document where you assign a trustee, sometimes it's a bank, which handles the distribution of the estate over a period of time. So I gave examples previously of documents which are effective during the planner's lifetime. And what are examples of documents which are effective during the planner's death? There's a written will and there's an estate trust. A written will is basically a document where the planner bequeaths which parts of his property or her property goes to which person. On the other hand, an estate trust is normally a document where the planner appoints a trustee who will be the one to distribute the estate to the different beneficiaries over a long period of time. But with the downside of this estate trust normally is there is an associated cost with the appointment of a trustee. So again, we go to the very basic question, which I asked a while ago. People have the impression that a will is estate planning, but that's not necessarily the case because estate planning would include a will. However, it would also include planning ahead of time before that ultimate situation where your estate will have to be distributed to your heirs. So this is where there's an interrelation between the documents which take effect during the planner's lifetime and the documents which take effect after the demise of the planner, in the sense that you will now be able to plan out how the estate will be distributed even while you are still alive. And then what you can do is after selling off all of your different properties or assigning the personal properties or donating different properties to your heir of choice, you will be left with certain properties which can now be covered by the will. And this is the will which will take effect after you pass away. So I'm not sure if a lot of people know this, but if you have been in charge of taking care of the estate of one of your relatives, you will know how difficult it is to transfer different properties. And these are three things your family will have to face if you pass away without an estate plan. First, you will have to go through the estate proceedings under the law. And what are these estate proceedings? Let's say you do not have a will and you do not have any debts. In that case, there are really two options. One is all of your heirs, every single one of them, must sign a deed of extrajudicial settlement of the estate. Once this is signed, this document can now be brought before a court and validated, and then this document can also be brought before the different government agencies, which will start the process. But what is the downside there? The downside here is that every single heir must agree to it. If just one heir out of multiple heirs does not agree to this extrajudicial settlement, then this will not happen. And in the event that just one single heir does not agree, you will now have to go through the court process. Now, the court process is very tedious. The court process normally takes at the very least 2 years. And during COVID, during this pandemic, it will definitely take longer than 2 years. And it's a very long process, which will require publication, which will require posting of notices. It will require the appointment of an administrator. It will require a collation of all of the estate. It will require a final accounting. And then the administrator or executor, in case of a will have to ask permission from the court to do anything, basically involving your estate. And it's only after this entire process is done that the properties can actually be distributed to your heirs. Also, I think I forgot to mention, it is important that the only situation where there can be an extrajudicial settlement of estate is if there is no will. If you have a will, you will have to go through the court process. However, it is also possible that even if you have a will, that all of the heirs will agree to the extrajudicial settlement. So having a will does not necessarily prevent the ease of having an EJ settlement, but the upside of the will is something I will be discussing later on. Now, after going through the court process, what else has to be done? For every real property involved, estate tax will have to be paid. Estate taxes right now for real properties is basically equivalent to around 6% of the capital gains. And before there's actually a transfer of the title to the heir, a certificate authorizing registration issued by the BIR will have to be issued. And same thing with personal properties. Even if they are personal properties, as long as there is some sort of documentation to prove ownership over these properties, for example, cars, shares of stock, membership rights, all of these personal properties which have documentation, you will need to again pay estate taxes before these can be transferred, and you will need to and the BIR will have to issue a certificate authorizing registration. And also, this applies to bank accounts. A lot of people are under the impression that if you have an end or account, any person named in the account can withdraw funds, notwithstanding the passing away of one of the account holders. This is not the case. For banks, the moment they have noticed that one of the account holders has passed away, they will not issue or they will not allow the transfer of any of the funds inside any of the accounts without a court order allowing the distribution or some proof of the payment of estate taxes. Also, in the event of an EJ settlement, also may normally require the presentation of an EJ settlement. So all of these circumstances make things very difficult for the heirs. And a question is, how are estate taxes assessed? I previously mentioned that the estate tax is roughly 6% of the value. And the value of this property is normally the fair market value at the time of the death of the decedent. Now, for example, let's say a decedent passes away in 1990, the estate taxes will be based on the value of the property back in 1990 versus someone who passed away, let's say in 2018, then the estate taxes will be based on the market value of the property in 2018. So it would appear that it would be better actually not to pay taxes right away and just delay the transfer. But that's not really the case, because while market value of properties do substantially increase over the year, it should also be noted that there are concepts of interest and penalties for non-payment of taxes, and these are quite substantial. The penalties and interests assessed by the BIR for non-payment goes beyond 50% cumulatively per annum. So if you don't pay a property back, the estate taxes over a property back in 1990, even assuming that it has a very low value, if you multiply all of the penalties and interests you will be incurring over the years, this would mean that the amount you will have to pay to the BIR would be substantially more over time as against the fair market value of a property, which or the recent fair market value of property. And then the last thing which will happen is after you go through that whole court process, after you go through the payments of the BIR, your properties will now have to be distributed in accordance with the laws of succession under the Civil Code of the Philippines. So I will give you a very brief overview on what are the laws of succession, because this will have relevance on what can be written down in a will. So what are the advantages of estate planning, which I explained previously has two components: the preparation of documents which take effect during your lifetime, and the preparation of documents which will take effect after you pass away. Right. The first advantage of estate planning is the ability to plan out expenses for transfers over a period of time instead of all expenses being paid as estate tax at once by the heirs. What does this mean? Let's say, for example, you have 5 properties, and out of those 5 properties, you will definitely have to pay estate taxes for each of those properties. So, assuming the planner passes away in 2021, that would mean the heirs of the planner will have to pay estate taxes of 6% times 5 properties. So that's effectively around 30 or a 30 unit. On the other hand, if you want to plan this out, you can actually execute documents where you could transfer the properties to your different heirs with one property a year. In that case, you will only be paying estate taxes of 6% every year for one property, instead of having to pay estate taxes of 6% for 5 properties all at the same time. And why is it also good to have a estate planning is because it minimizes the involvement of the probate process or the estate settlement process. And it minimizes the delays in the distribution of the properties to the heirs. What's an example of this? A good example would be, let's say you have you anticipate that some of your properties would be contested, or it would be highly contentious between your heirs in case this is distributed through the court. So what you can do is you can pick out these properties which you think will be highly contested, and you can distribute them already to your heirs before you pass away. And what will be left among all of your properties will be the ones you do not think will be contentious. And in that case, since everything is distributed, it will now become easy to either enter into an extrajudicial settlement for that remaining properties which are uncontentious, or the heirs can also opt to continue with the court process and get the will probated before the court. And it will be unlikely that the heirs will have any incentive to try to delay the proceedings because the remaining properties will be uncontested. And another thing is that you will have an ability to determine the manner of your distribution of the different properties. Because if you do not engage into estate planning, there are limitations on what can be bequeathed through a will. And in the event this happens, you will not really have a choice but to give certain heirs different properties. On the other hand, if you engage in estate planning, all of these properties can be distributed to the exact heir you want them distributed to, and without having to take into consideration the issues involved in the distribution of properties under the civil code. Yeah, the number 3 and 4 are interrelated. So as I explained a while ago, it will be necessary to have a very limited understanding, at least, of the types of succession in the Philippines, because this will indicate what can and cannot be included in a will. There are essentially three different types. There is compulsory succession, testamentary succession, and intestate succession. Intestate succession occurs when a decedent passes away without a will. And on the other hand, testamentary succession is succession through a will. Compulsory succession is really interrelated with testamentary succession because under Philippine law, you're not allowed to distribute your entire estate in a will. You're only allowed to distribute your free portion because a certain portion of your estate is reserved for compulsory heirs. And that is compulsory succession. And also, something important to note is a lot of people normally have the question, so what forms part of my estate which will be distributed in case I pass away? Now, there is a distinction between single and married individuals. If you're single, all of your properties which you own at the time of your death will belong to your estate. On the other hand, if you are married, there will now have to be a question. The first question will be, do you have a prenuptial agreement or not? If you have a prenuptial agreement, then you will have to examine the prenup to see what exactly is the property relation between the spouses. But prenups are not really common in the Philippines. So normally the next question to be asked is, when there is no prenup, when did you get married? If you got married before the issuance of the family code, which was sometime in the 1980s, the property relationship is most likely the capital partnership of gains. It's essentially a loose partnership for property ownership. On the other hand, if you got married after the 1980s, after the issuance of the family code, your property relation is governed by the absolute community property. This essentially means that you and your spouse are co-owners of practically all, if not all, of your properties. So this is really where the concept of what is mine is yours. That's essentially the community property. So if it is covered by the conjugal partnership of gains or absolute community property, normally, as a general rule, half of the estate belongs to your spouse. So this is not part of your estate. Sorry, half of the partnership or community property belongs to your spouse, and this is not part of your estate. Your estate will only be one half of all of these community or conjugal partnership properties. So what is compulsory succession? Compulsory succession is the passing of property of the decedent to his or her compulsory heirs, and compulsory heirs are entitled to a portion of the estate of the decedent in accordance with the proportions mandated by the Civil Code. I know these are a lot of words, but it will be more understandable once you read through the provisions of compulsory succession, because it's hard to exactly state how much an heir is entitled to. Instead, what that code provides is some sort of formula to determine exactly how much each heir is entitled to, each compulsory heir is entitled to. So, but the more words here would adequately describe what the compulsory heirs are entitled to. So, who are the compulsory heirs? The compulsory heirs are legitimate children and descendants. If you do not have any legitimate children and descendants, then this will go to the ascending line, meaning your parents and their ascendants. Then the next compulsory heir is the surviving spouse. And the last form of compulsory heir would be illegitimate children. Just note, normally under compulsory succession, illegitimate children are entitled to half of what legitimate children are entitled to. And normally, the surviving spouse is entitled to exactly the same amount which a legitimate child is entitled to. And also some people ask normally about adopted children. Adopted children uh, are not considered descendants. The relationship of an adopted child is only legally with the adopting parents. The adopted child has no relationship with the grandparents, and the adopting parents has no relationship with the children of the adopted child. So therefore, the children of an adopted child are not considered descendants for purposes of being compulsory heirs, and the parents of the adopting parents are also not considered ascendants of an adopted child. So what portion of the estate is actually reserved for compulsory heirs? Like I said previously, what the civil code provides basically a formula to compute exactly how much the compulsory heirs are entitled to. But as a general rule, it would be roughly around one half of the estate, while the remaining half, that is what you consider your free portion, and this part of the estate is what you can distribute through a will. So what are exceptions to the general rule? And to be frank, these exceptions are actually quite common. So there are a lot of instances where the portion reserved to the compulsory heirs is actually more than 50%. Some examples are if you're married and you have two or more legitimate children or descendants. If you're married without legitimate children but you have illegitimate children, if you're married with both legitimate and legitimate children, or you are married with a surviving legitimate ascendants and with legitimate children. In all of these instances, more than half of the estate is reserved for compulsory heirs, and that would mean a smaller amount of will be a free portion which can be distributed through a will. If you notice the first situation, that's actually quite common, married with two or more legitimate children. So, as I mentioned a while ago, there are really two forms of succession: testamentary succession and intestate succession, with compulsory succession essentially being interrelated and highly involved in testamentary succession. Okay. So after testamentary succession, there is intestate succession. And who are considered heirs in intestate succession? It's legitimate children and their descendants, legitimate parents and their ascendants, illegitimate children, surviving spouse, brothers and sisters, nephews and nieces in the state. Now, if you notice, the first four are essentially the compulsory heirs, and then the fifth and sixth are not considered as compulsory heirs. And what does this mean? In intestate succession, you're only the brothers and sisters, nephews and nieces will only be able to succeed in the event that the first four cannot inherit. So the only time that there is actually a brother and sister or nephew and niece who can become an heir is if the decedent does not have legitimate children, does not have descendants, does not have legitimate parents, nor do they have ascendants, and does not have a surviving spouse. And it's only after, in the event that there are no brothers and sisters or nephews and nieces, that it will be possible that the state will succeed or will inherit from the decedent. So in the event that you do not have a will, and you do not have children, and you do not have a spouse, nor do you have brothers or sisters or nephews and nieces, all of your properties will go to the state. Given that it is highly possible that the properties can go to the state, it would then make sense that instead of it going to the state and you not having control, then it would make sense to indicate exactly in a will to whom you will be bequeathing the properties instead of the state. Because as I stated before, intestate succession only occurs when there is no will. However, if there is a will, your free portion can go to whoever you want it to go. And instead of it going to the state, then perhaps it could also go to legitimate institutions, for example, UNICEF. So those institutions can actually be beneficiaries of a will. Now, given the importance of a will, and I understand this is exactly why we're here, uh, my partner, Ms. Raquel Tagian, will be explaining how exactly to craft the will in order to comply with the requirements under Philippine law.
Okay, thank you, JA. I'm here to discuss basically how to make a will. Since JA earlier discussed already or has given you a brief background of estate settlement, I guess it boils down now to how do you make a will. Okay, before we go there, I'd like to discuss with you the different types of a will. You have a holographic will and you have a notarial will. Okay, I will be discussing later on the advantages and disadvantages of these two types of will so that you can decide for yourself which is more appropriate for you. Okay, a holographic will is basically a fully handwritten will. It should be in a language or a dialect known to the testator. It should be dated and it should be signed by the testator at the end. Any additional dispositions or insertions, cancellations should be countersigned by the testator. Okay, the other type of will be the notarial will. It must be in writing in a language or dialect known to the decedent or the testator. A testator is basically what you call somebody who writes his will. Okay. For a notarial will, the decedent or the testator has to sign each and every page in the presence of all three witnesses. Okay. It has to be signed also by all three witnesses in each and every page and in the presence of a decedent. In other words, in one event, the decedent should be there, all three witnesses, and one more person, which will be the notary public. I'll discuss that later. Okay. For the three witnesses, they all should be at least 18 years of age, of sound mind, able to read and write. They're not blind, deaf, or mute. They're domiciled in the Philippines. They're not convicted for crimes of falsification of documents, perjury, or false testimony. And if the witnesses, or the spouse, parent, or child, they must not be recipient of anything in the will. Okay. Aside from this, the notarial will should have an attestation by the notary public stating all the items in 1, 2, 3. Okay. It should be also in a language known to the testator or the decedent and all the three witnesses. And then finally, the will is notarized before a notary public. Okay, you might ask, why would I go through all the trouble of creating a notarial will when I can just simply get a piece of paper and do it myself, write it down myself? Okay, the difference between a notarial will and a holographic will come in when you are to prove it in court. Okay, eventually, a notarial will is easier to prove in court because you have the required witnesses who will testify and tell the court that this will was actually done by the decedent or the testator. For the holographic will, you would have to call witnesses who are familiar with your handwriting, and in the absence of that, you'll have to get an expert witness to identify your handwriting. The other difference is that with a holographic will, there's a possibility that nobody would know about it. But in a notarial will, at least you have witnesses who would know that there was actually a will executed by you. So these are the advantages and disadvantages of the two types of wills. Okay, who can prepare a will? Any person 18 years old and above can actually prepare a will. The only requirement is that the person must be of sound mind. What do you mean by having a sound mind? It's actually, simply put, it's just knowing what you're actually doing, which is you have an idea of how much property you have, and you know that by writing the document, you will actually be transferring these properties upon your death to certain individuals. So for as long as you're able to understand what you're doing, then you would be considered someone of having a sound mind sufficient to be able to execute a will. What law governs the form of a will? You For discussing this, there will be two types to consider. One would be the substantive portion of a will, which is the content, and actually the form of a will. For the substantive portion, normally this will be governed by the nationality of the testator or the decedent. In a will, you will normally have your dispositions or the properties. You'll be specifying the properties that you want to dispose. You would also specify an executor who will essentially implement the provisions of your will. And finally, in some instances, there's actually the testator or decedents who would write a disinheritance provision in a will. Okay, this will actually all be governed by the law of the nationality of the testator. As for the form, with regard to determining whether what law will govern the form of a will, it's dependent on whether the testator is a Filipino. If he's a Filipino, the law provides that he may execute it in accordance with Philippine law. Or if he is not in the Philippines and he executes the will abroad, it can also be considered the form of the law rather governing the form of the country where he is executing the will. Okay, if he is a foreigner, there are a number of acceptable laws that may be applied. One would be the law of the place where he currently resides, or it could also be in accordance with the formalities observed in his own country where he is a national. And it can also be in a form compliant with the form prescribed under our laws, Philippine laws. Okay, so what are the properties that can be distributed through will? As Attorney Lopez earlier discussed, you have to comply first with the compulsory succession, which means that you have to ensure that your compulsory heirs are given the mandated amount that they should receive under your will. And the excess, that's the portion where you can actually distribute it to other individuals or other entities. Okay, so who can be a beneficiary in a will? Okay, first can be your compulsory heirs. Second, it can be any individual. Okay, you don't need to have a relationship with that individual. And then the last would be either a corporation or an institution, charitable institution in this case. For example, you'd like to donate or give a portion of your estate to UNICEF. Okay, this will be the best way to do it. As Jay said, without this, all your properties will go to the state if you have no other heirs. So in essence, it gives you control as to who will benefit from your estate at the time of your death. Okay, so how do you actually dispose the property in a will? It would be best to state the name, the first name and the surname of that individual that you'd want to indicate in your will. Okay, there are other ways to determine the individual, but it would be best that you specify the heir or the legatee or the devisee as specific as can be. Okay, so we recommend stating the name and the surname. Okay, the amount of share also should be specified, because if you don't specify the amount of share, then it will be assumed to be in equal parts. Okay, there's also possibility that you'll be naming multiple people as heirs. So, for example, I bequeath to Tom, Dick, and Harry 1/3 of my estate. Then, since you do not specify the properties, it will be assumed that it will be in equal parts distributed among them. Okay, and in this case, there's no distinction as to full blood, half blood, or which relationship or degree of relationship is closer to the testator or the decedent. And again, it applies also to institutions. If it's just, for example, I bequeath my one third of my estate to these institutions, then the assumption is that it will be distributed equally. If there's an instance when the legitim or what was mandated to be part or given to your compulsory heirs, if that's not sufficient, then the portion of your estate distributed to other individuals or institutions who are not compulsory heirs will be equitably reduced and given to your compulsory heirs. Okay, are joint wills allowed? What are joint wills? Basically, joint wills are maybe a husband and a wife will just write one document and distribute their property. Sometimes it's for convenience since most of the properties are jointly owned by the spouses. But this is not allowed in the Philippines. Why? Because drafting a will is a personal act, and there are also some instances being avoided by our civil code in prohibiting execution of a joint will. Okay, like for example, there are instances that it tempts the other spouse, to do harm to the other spouse just so that they'll be able to benefit from the joint will. So these are the instances which they want to avoid. Okay, finally, once you have the will, um, you will have to submit it to the court. Okay, it's what you call a probate proceeding. This can be done while you're still alive. Okay, this can also be done after your passing. Okay, so what is a probate proceeding? It's technically you submitting your will to the court, and the court will just make a determination whether your will is compliant with the formal requirements under the law. Okay, compared to intestate succession, this will be much, much faster because there are just a few things that need to be determined by the court. Okay, it's only in instances when the will is opposed by any individual that they're required to actually present more witnesses. Now, who are normally the ones who file the petition in court? During the lifetime of the testator or the decedent, sometimes it's himself. Okay, but if he has passed on, your petitioner could be the executor named in the will. It can be also any of the compulsory heirs, or actually any person who has interest in the probate of the will. So there. I hope our discussion was clear, and we'll be willing and most welcome to entertain any of your questions.